Good morning, and thank you for coming to representing juveniles at sentencing in adult court in the post-Roper, Graham, and Miller era. I'm Vanessa Antone, Resource Counsel for the National Association of Criminal Defense Lawyers, and we are pleased to be partnering today with the Juvenile Law Center, the National Juvenile Defender Center, and the Campaign for the Fair Sentencing of Youth to bring you this program that is supported by funding from the Foundation for Criminal Justice and the Ford Foundation. Now, as many of you know, the recent landmark U.S. Supreme Court decisions in Graham, Miller, and Jackson have greatly affected the representation of juvenile clients, especially the sentencing of juveniles, and really all aspects of representation, especially when you represent a juvenile in adult court. Now, these decisions will be explained, so I'm not going to go into detail, but we have a great panel here to facilitate this discussion and teach you some things about those decisions and your representation of juveniles. Now, this morning we have Carol Kolinchak, and Carol is currently the legal director at the Juvenile Justice Project of Louisiana. Prior to joining JJPL, she was the deputy director of the Capital Post-Conviction Project of Louisiana. She's been representing indigent defendants in Louisiana since she began practicing law in 1993. For almost a decade, before joining CPCPL, Carol represented indigent defendants at the trial level in both state and federal court, primarily in capital cases, including a number of juveniles facing either the death penalty or mandatory life without parole. Most recently, in partnership with the Equal Justice Initiative, Carol coordinated development of Louisiana's litigation strategy for implementation of the U.S. Supreme Court's decision in Graham versus Florida. Seated next to Carol is Stephen Harper. Stephen serves as co-coordinator of the Capital Litigation Unit in the Miami-Dade, Florida Public Defender's Office. He is primarily responsible for the gathering and presentation of mitigation evidence in capital cases. From 1989 to 1995, he served as chief of the Juvenile Division. In 2002, he took a 2-year leave of absence to coordinate the Juvenile Death Penalty Initiative, a project ending with his oversight of the drafting and filing of the amicus brief in Roper v. Simmons. Seated next to Paul is Marsha Levick. Marsha is Deputy Director and Chief Counsel and co-founder of the Juvenile Law Center. Throughout her legal career, Marsha has been an advocate for children's and women's rights and is a nationally recognized expert in juvenile law. Marsha oversees the Juvenile Law Center's litigation and appellate docket. She has successfully litigated challenges to unlawful and harmful laws, policies, and practices on behalf of children in both the juvenile justice and child welfare systems. Marsha also spearheaded Juvenile Law Center's exposure and subsequent litigation arising out of the Luzerne County, Pennsylvania Juvenile Court Judge's corruption scandal, known as the Kids for Cash scandal, where the Juvenile Law Center successfully sought the expungement and vacatur of thousands of juveniles' cases before the Pennsylvania Supreme Court, and is currently pursuing civil damages for the children and their families in a federal civil rights action. Marsha has authored or co-authored numerous appellate and amicus briefs in state and federal appeals courts throughout the country, and she co-authored the lead children's advocate amicus brief in Roper v. Simmons, where the U.S. Supreme Court struck the juvenile death penalty under the Eighth Amendment. Graham versus Florida, where the U.S. Supreme Court struck life without parole sentences for juveniles convicted of non-homicide offenses, and JBD versus North Carolina, where the U.S. Supreme Court ruled for the first time that a juvenile's age is a relevant factor to the Miranda custody analysis under the Fifth Amendment. Seated where I'm going to be seated is Sonia Rudenstein, and Sonia started her career as a staff attorney at the Equal Justice Initiative in Montgomery, Alabama, and now owns her own private practice in Gainesville, Florida. Sonia handles primarily criminal appeals and post-conviction proceedings in the capital and other serious felony cases. Sonia also serves as co-chair of the amicus committee for the Florida Association of Criminal Defense Lawyers. In that capacity and in others, she's worked extensively on developing litigation and other strategies to stem the erosion of quality defense for indigent clients. Since the Supreme Court decision issued in Graham versus Florida, Sonia has served on both Florida and national task forces charged with the strategic implementation of Graham and subsequently Miller versus Alabama. So I will turn it over to our moderator, Marsha Levick. Thank you.
Thank you, Vanessa, and welcome to those of you in other offices in other states across the country who are joining us this morning. We are here this morning to have a conversation with a very seasoned and experienced group of panelists to talk about the lessons learned from Graham versus Florida, and to discuss and hopefully share insights, of course, about how we think those lessons learned may be relevant to litigation going forward under Miller. Very quick introduction and overview of what these two cases stand for and why we're having this discussion this morning. In Graham versus Florida, the Supreme Court struck juvenile life without parole sentences for cases of juveniles who were convicted of non-homicide offenses. As a consequence, primarily in Louisiana and in Florida, approximately 130 juvenile offenders who were serving those life without parole sentences were entitled to new sentencing hearings. Those hearings are not yet complete, and that process is still unfolding in both Louisiana and Florida and a couple of other states. And the lawyers who are here today all have had direct experience in both negotiating and in trying some of those cases that were entitled to resentencing. 2 years after the Supreme Court decided the Graham case, the court decided Miller versus Alabama last spring, in which the court declared that mandatory life without parole sentences were also unconstitutional under the Eighth Amendment in homicide cases. In the Miller case, unlike in the Graham case, we know that there are 28 or 29 jurisdictions affected, and we know that the number of potential juvenile offenders who are serving these sentences is as high as 2,100. So we are facing a very different landscape, a much more complicated and challenging task, but we believe that what happened in the wake of Graham and the experience that each of our panel members had in the wake of Graham will be directly relevant and really, frankly, impart lessons learned, which is the title of this panel, to those of you who will be handling Miller cases going forward. So that's, I think, all that you need to know as a background for why we're here today, and we're going to begin this conversation. We will also, as I know, be taking questions. There will be an opportunity for questions to come from the audience who is listening, and we will endeavor to answer those questions throughout the course of the session. We're going to start this morning with a very fundamental question for lawyers, and that is, how was representation secured for the Graham individuals who were entitled to resentencing? Was it a public defender system? Was it a private counsel system? Was it some combination of the two? So I'm going to start with that question. I'm going to turn to Carol first and ask her to tell us the experience that they dealt with in Louisiana.
Good morning, everyone. In Louisiana, there is not a right to post-conviction counsel, with the exception of capital cases. So the vast majority of those that we identified who were impacted by the Graham decision had no representation. And so we were left with the challenge of how to represent them and how to go forward. What we ultimately decided to do, and what we were able to do successfully, is partner with the Equal Justice Initiative in Alabama and undertake representation of all but 3 who had hired their own counsel. And so we were able to coordinate the representation in that way.
And Sonia, in Florida?
In Florida, we have about 60 cases, and we had a bit of a hybrid start to representation. A lot of the cases came forward because inmates themselves filed motions to correct an illegal sentence, which one can file at any time in Florida. And those folks went forward, and they are entitled to counsel if there's going to be a hearing. So we had a few people out of the box who got private conflict attorneys or public defenders appointed after filing those motions, and they went through quite quickly. Once we realized that and started coordinating with other folks, including the Equal Justice Initiative, we had a bit more of a coordinated approach, and public defenders can represent these folks in post-conviction, so that was not an issue. We had one public defender office that has still not taken any cases, and to the extent that the PDs aren't taking cases or can't, we have private attorneys doing the work, and we have the benefit of an organization funded by Soros at Barry University, which is a juvenile life without parole project, and has served as kind of a coordinating clearinghouse for us. So now that we are slightly more set up, we've been able to track every case and find lawyers for everyone mostly. And I would give a shout out here to Factal and NACDL. Over 20 of those cases, or 25 of those cases, I believe, are private Factal attorneys doing this pro bono. Some of them have been retained by families, and about 30 are represented by public defenders. And I think there are still almost 7 or 8 who are unrepresented who we're trying to find counsel for. But at this point, at least we know who everyone is, and we've got a pretty good system in place.
Going forward in Florida, do you anticipate a similar process being undertaken for representation for the Miller cases?
I do, yeah, and many of them, if not most, have already been identified. The other benefit that we had in Florida in Graham, of course, was that Graham and Sullivan were both Florida cases, so EJI had done a lot of the legwork of identifying how many cases there were and who they were, and we don't have as good a handle on that in Miller because the numbers are so high, but we certainly have, I think, identified most of the cases at this point, and Barry's been a huge help,
Right.
and the Department of Corrections has actually been helpful.
And in Louisiana, Carol, what do you see the landscape looking like for the Miller cases?
I think for the Miller cases, the landscape is going to be a lot more similar to what was done in Florida because the numbers are so much greater. And so we have formed sort of an oversight or a legal committee to start to address those issues. We've reached out to some of the law schools that have criminal defense clinics about working on the cases with us as well.
So it sounds like one of the important messages here is to think about some type of central coordinating panel, whether it is your state association of criminal defense lawyers, whether it is a local law school that might be able to provide that type of coordination. But again, with the numbers so much higher in the Graham and Miller cases, it's imperative that folks who are going to be working on these cases think about ways early on to centrally coordinate the representation issues, whether it is a public defender system or whether you're dealing with a private counsel issue. One of the other issues that I know was immediately on the table for lawyers representing individuals in the Graham cases was to think about, this was an issue about parole. These were life without parole sentences that had been struck, and the question, of course, became, if not life without, is there a parole system in place? I know that the experience, again, was different in Florida and Louisiana, so I'm going to ask Steve to talk about this issue about what do you need to know about state law, and how did that drive your work going forward?
Well, in Florida, at least, there was no parole system. Florida abolished parole many years ago, so all of these kids had to be resentenced. And so one other thing I'll tell you about, just to add to what you were saying before, is that we worked closely with the Department of Corrections. We made relationships with various people in the Department of Corrections, and we got them to narrow the people that were eligible for Graham relief, and we're going to try to do the same thing in Miller. But every person in Graham in Florida is entitled to resentencing, and so once you have identified those kids, you have to, as we said, get them lawyers. And then the process, if that's your question, is really, I would say, 90% of my cases have been resolved by negotiations. I mean, I would tell you that I think negotiating these cases is, in most cases, the best thing to do.
And by negotiating, that also meant that you were able to sidestep the parole problem.
Correct. Absolutely. By negotiating the case, parole is not an issue. And I would say that I have 2 cases left where we're going to litigate the sentencing. I don't think I'm going to be very successful in those cases for a variety of reasons, which we can talk about. But all the other cases I resolved by working out with a prosecutor. And we can get into all the reasons why you should do that and all the things you can do.
Let me stick with the parole question for a minute. So in a state like Florida, where you don't actually have a parole system in place, has there been a legislative response to deal with that?
Interestingly enough, we anticipated after the first year of all these cases in Graham that the legislature would act and reinstate parole in some form or do something and they didn't. I was told, it's a little bit funny, there was a legislator who had legislation, he was a Republican, but because he did not support other bills, they never called his bills. And so one of his bills was this, and a fix-it bill, and it was not passed. So we're waiting to see if that happens with Miller. We're anticipating the Florida legislature doing something about Miller, but they did nothing about Graham.
But 25 years and then parole has been sort of what they've been talking about.
Right.
That you have the opportunity for a parole hearing after 25 years. That's kind of always been on the table, but they haven't gotten anywhere with it.
What was the experience in Louisiana, Carol?
In Louisiana, we do have a parole system. However, the law was very clear that if you were serving a life sentence, whether it was designated life with parole, life without parole, you were not eligible for parole unless and until you received a commutation from the governor. And of course, Graham had directly addressed that issue and said by requiring that extra gatekeeping step, that was not sufficient. So we were left without any parole option for those serving a life sentence. And so what we did, and I'd just like to emphasize what Steve was talking about, was the importance of negotiations in those cases, because early on we were able to go in and negotiate successfully in cases, and again sidestep that whole thorny issue of parole.
Now, Miller has been law for not quite 3 months. In your states, what are you hearing in terms of, again, you have a much larger population in both Florida and in Louisiana. You have 200 to 300 individuals who are likely affected. What do you anticipate this parole or lack of parole system in place, how is that going to be dealt with in the Miller cases?
Well, the state prosecutors have gathered together and they've come up with their solution, which is in all these Miller cases, which are going back in front of the court, in the trial court, they're basically saying, look, all you can do, we can fix this instantly. Give kids that are sentenced to life without parole, you can revert to the prior statute, giving them opportunity of parole after serving a 25-year sentence. That takes care of the mandatory life without parole issue. Nobody goes to court. They just are eligible for parole after 25 years. That's being litigated. Because because the parole board was abolished in Florida, the Florida Supreme Court would be making law, at least as to what the parole board should and should not do. And that obviously is a conflict of violation of their powers. And the other thing is there are lots of kids who may get some relief better than 25 years. So a lot of public defenders and a lot of other lawyers are contesting that for other reasons. And we're just going to have to see how this all plays out. But it's all getting litigated.
I think that this is a lesson that we know that there are many jurisdictions around the country that, of course, in the 80s or 90s did abolish parole. And this sorting out of what the options might be where you don't actually have a parole system in place is one that, in some respects, we have the benefit of this being played out initially with respect to Graham cases. We know this will be an issue in Miller cases. One of the things that Steve just mentioned was this notion of reverting to a lesser sentence or a different sentencing statute. So I'd like to talk about that, and I'll ask Sonia to talk about in Florida, once you have, and this will be an issue in the Miller cases, if you take a sentence off the books, so we've taken mandatory life without parole off the books, is there a sentencing scheme in place that courts may automatically look to? And if not, what do lawyers do in those cases? So what was the experience in Florida?
So we do have a sentencing scheme in place because unlike in the Miller cases and Graham, the sentences were all you could give up to life without parole for a non-homicide offense. And so there was a whole range of years that a juvenile could get. They ended up with life without parole, but now they can go back and get some kind of a term of years within that same statute. Now there's an exception to that. Before 1995, we had a statute on the books that provided either for a 40-year sentence or a life without parole sentence. So for the folks who got life without parole, our argument was you got to give them the 40 years, otherwise the statute essentially is being ignored. And so our goals were to work on those cases first, where we didn't have to have a hearing and litigate all of the criminal issues. And we would just go and present a legal argument to the court. It's a very simple fix. You just give them 40 years and we're done. And in a lot of instances, the state attorneys would agree to that as well. We had a number of people released early on based on this strategy, and we didn't have to go air out all of the issues associated with the crime, which we felt would be quite damaging. So I think about 10 people were released under that strategy. Now we're faced with the people after 1995 for whom we're trying to get terms of years. And, again, as Steve says, I think the strategy is still negotiation. I think you don't want to risk having a hearing, and in some cases the hearings have come out well, but in many cases they've come out 100 years, 170 years, the whole gamut in Florida. And so you want to use that. The other thing I would mention is that many of you may have statutes for direct filing in adult court that have some language in it that can be challenged. For example, and I don't know the specifics of your states, but if the decision to charge a juvenile as an adult can be relitigated because there's some language in that direct file statute that speaks about life or life without parole as a sentence, that's worth looking at as well. So you want to sort of play around with your statutes as much as possible to avoid getting to court, frankly.
And in Louisiana, what were your options in terms of sentencing?
In Louisiana, all of our Graham impacted clients had been convicted of either aggravated rape or aggravated kidnapping. In both instances, the only sentence available was mandatory life without parole. So under that statute, there was no other sentence available. We looked back to our death penalty cases back from the 70s when the United States Supreme Court had struck down mandatory death sentences, and in Louisiana it had been a mandatory death sentence for aggravated rape. And what the court had said at that point was that what you do is you look at the next most serious lesser included offense and you sentence under that scheme absent any legislative action. And so we used that line of cases to argue that the same should apply here. We also had in Louisiana, we have a very specific code article that addresses illegal sentences and says that a motion to correct an illegal sentence can be filed at any time. And our position was that an unconstitutional sentence was an illegal sentence.
In in Louisiana, in terms of the specifics, when you were able to revert to, or maybe arguments to revert to a lesser included offense and therefore the next most severe sentence, what did that look like?
Well, we had to look at when, at the time of the offense, because the law had changed over the years, and I think this is true around the country as more mandatory sentences and more harsh sentences started to be enacted. And so what we found is for our longest serving people, the next lesser included offense carried a sentence of 0 to 20 years. And so strategically, we looked at those cases as cases to move forward with first because the potential outcomes were much better. After 1976, the lesser included offense sentencing scheme changed to between 10 and 50 years. And so in looking at it, we wanted to go through with the earlier sentences, get some better outcomes to establish where within that range of 10 to 50 years fair sentences should occur.
And I think that this issue is one that we will see cropping up probably across the country. As each state begins to consider what are the options in place as a consequence of these sentences being struck down in Miller, that I think the two lessons coming out of here are both to think about the next most severe sentence or lesser included offenses. And there is substantial case law that is available from the death penalty cases. When the death penalty was struck in the 1970s, both initially in Furman and then in Woodson, you had states that had to figure out what do we do now. And I think that there are lessons there that we have been certainly suggesting would be equally applicable in these Miller cases. Now, Carol raised this issue as well about being able to challenge a sentence at any time if it's an unconstitutional sentence. Let me ask you, Steve, to talk about both the relevance of that issue that may be true in states across the country, but also to just say a little bit about retroactivity, if this was an issue in Graham, and how it played out.
Well, in Miller, retroactivity seems to be an issue in some states. It's not an issue in Florida. The Attorney General in Florida has conceded that issue. So fortunately, we don't have a retroactive problem with Miller. And in Graham, it's not an issue either. But in Florida, because there is no parole system, all these cases are coming for resentencing. And so what we're doing is to resentence all these cases. And your other question, what's the other part of your question?
This notion that you can challenge an unconstitutional sentence at any time.
Right. Well, that is the law in Florida, although I'm told that there's a law coming up in the legislature to ban that for 2 years. So in Florida, possibly there will be a 2-year limitation by statute on
Well,
that.
no, it's a rule. It would
A
be a
rule.
rule from the Florida Supreme Court, and we
I'm
don't
not quite
know
sure.
if it will happen, but there's always a chance, so you don't want to sit on your
Right.
laurels too much.
Right. But as we stand right now, an illegal sentence can be challenged at any time, and that's the position we've taken in the pleadings, which, by the way, what we have done in Florida is there is what we call Rule 3.850, which is a post-conviction remedy, and there's also the illegal sentence remedy. We have our initial pleadings include both of those statutes, just to be on the safe side. And so what we do is we file a Rule 3 and we file a Rule 3.850 and a Rule 3.800. So both of those issues are included in the same pleading, therefore protecting our client in every way possible. And that's really an important thing.
Yeah, and I'm sorry.
No, go ahead.
And I was just going to say, as far as that, because there's a 2-year limitation in Louisiana for seeking post-conviction relief, and a 1-year limitation, of course, for going into federal court, we filed all of our applications for relief, all of our motions to correct an illegal sentence within the 1-year time
Right.
frame to make sure that we did not waive anyone's rights to proceed further should that be necessary.
And I would underscore that this is not, our conversation this morning is really not intended to be a nuts and bolts about filing for post-conviction relief, but it is important to remind everyone that in every state that is affected by Miller, there is a time limitation. It could be as short as 60 days in a state like Pennsylvania. It could be 2 years for state relief in a state like Louisiana, and of course 1 year for federal habeas. But that's perhaps the first step that everyone needs to take, which is to be sure that you know what your timeline is for filing for relief under Miller. There are templates that I know are circulating on the web through certainly the Graham litigation listserv, and I think can be reached and accessed through probably the NACDL website and also the Campaign for the Fair Sentencing of Youth. But that is a threshold issue that everyone needs to be thinking about.
I would just add that on the retroactivity issue, basically we feel, or I feel, and I think in Florida we agree that we should not be litigating retroactivity. We should assume that these cases are retroactive, and now we have law on point in Florida saying that, but as Miller comes forward, we're using the same strategy, which is to say that we're assuming that this is retroactive, and in fact in Jackson's case it was a habeas case, so there's good evidence for that, and you've got a dissent in that case bemoaning the number of cases that will be reversed, and I think you can apply that language in Miller to Graham cases as well if retroactivity isn't something that's been decided. Let the state raise it if they're going to raise it, and then you can respond, but overall we've taken the approach that these are clearly retroactively applied cases.
And I think that that's one of the surprises that we've seen in Miller, which is that we're not seeing an across-the-board issue about retroactivity across states. It has been raised in Pennsylvania. It has been raised in Colorado. It will likely surface in some other jurisdictions, and these issues will be litigated in the state appellate courts, but certainly it's true in Florida. Is this true in Louisiana, that you're not expecting a challenge?
We are not expecting a challenge in Graham. In our Graham cases, the Supreme Court held that it was retroactive, and there was also a Fifth Circuit case in Ray Sparks, which found Graham to be retroactive.
Okay. So let's turn to, once you realized that you had a problem, you had a system for ensuring that counsel were appointed, How did you actually identify the cases, and how could you be sure that you had identified everyone that you needed to identify? So let me ask you, Carol, first to talk about Louisiana.
We had a couple of things, and what we found is that that the numbers that were being provided to us were not accurate, and so we had to be very careful about that. In the Graham decision itself, in Louisiana, there were 17 people identified because in Louisiana, at the age of 17, you're automatically considered an adult. So they weren't originally factored in. Subsequent to the Graham decision, the Department of Corrections identified 48 people. What we found is through self-identification and through our work in Louisiana with families and those on the inside through an organization called Citizens for Second Chances, we identified a number of other people that had fallen through the cracks, and a couple of particular areas to watch for with that. Those with mental illness or mental retardation, those who've been locked up for a long time and sort of are in either lockdown or other outlying camps and don't have as much communication. And we had at least one person who, while in prison, had lost his vision, and so as a result, the written communications and other information weren't getting to him. We got a lot of help from inmate counsel who were able to, because of the time they had served, their relationships on the inside, able to identify some of the people who had gotten through the cracks. And through that combination of gathering of the data, we were able to identify what we believe is all of the Graham impacted clients. And I will say the Department of Corrections was extraordinarily helpful with that. They allowed us to come in and address those who they thought might be impacted by this, so that we could talk about who it applied to and who it didn't, in an effort to make sure that we sort of widened the net to all of those impacted.
And I think the point that Carol just made about being mindful of individuals who may have significant mental or physical impairments, also individuals who may be in disciplinary segregation, may not actually have access to paperwork or to the ability to actually file. So in also thinking not just about identification issues, but in also thinking about how do we ensure that everyone meets those filing deadlines, to also pay attention to those individuals who really may be falling through the cracks because of their status in the prison or particular disabilities that they may have. Sonia, could you talk about how you've dealt with the identification process in Florida?
Yeah, I mean, again, we had a running start because of the work that EJI had done to identify the juveniles for purposes of the litigation that went up to the Supreme Court in Graham. So there was that list, and then once we got Barry involved, they served as a clearinghouse, as did the public defenders who, and Steve can tell you, were identifying their own cases either through DOC or their staff, and DOC in Florida has been very helpful, and they do have good research, and so they have provided names. In some cases, the list was perhaps over-inclusive, so you have to be skeptical of what you get, but if you have a cooperating DOC, there's no reason not to use those resources. And then, you know, we do identify a number of folks just from them writing.
Right.
And if you have the word out, they'll either write a public defender, or they'll write Barry, or they'll file their own motion, and some of the cases come forward that way.
I think one of the things to be mindful for also is that oftentimes departments of correction count juvenile lifers by looking at their age when they came into the prison system. And of course that will often be a couple of years off or more from their age when they committed the crime for which they were convicted. So also, I think that's the reason for some skepticism when you get initial lists, to try to ensure that you have captured everyone who was actually a juvenile at the time of their crime. Let's turn to really what you did with these cases under Graham in terms of ultimately trying to seek resentences. So in Florida, Steve, you've talked a lot about the negotiation process. How did you determine which cases to negotiate? Why did you start with negotiation? What was the process that you had in mind for how you were going to deal with these cases after Graham?
Well, the first cases we did, as she said, is that were the cases where we knew we could get legal relief, and that was that, because the way they were sentenced, at the time they were sentenced, and Florida law has changed 4 or 5 times since in the last 20 years. And so you have to know what the law was at the time your client was sentenced. But there were some clients who basically got 40 years, and because of their gain time at the time, they got out. The trickier cases were the cases where the client would still have to serve some sentence, and what the judge would sentence him to, whether it was 100 years or whether it was going to be 40 years or 30 years, that had to be negotiated. We started with the cases where the clients had behaved very well in prison. We tried to figure out who a good prosecutor was, for example, who the judge was, how well had our client performed and done in the prison system, how much gain time could he have earned, and what were his chances of getting out. Who the judge is, who the prosecutor is, and how well your client has done in prison. And that's a long process in itself, discovering how well he has done, explaining in some situations that this is really, he has 20 disciplinary reports, as we call them, DRs in Florida, that actually it was minimal stuff. He didn't go where he was supposed to go, as opposed to he slugged somebody. So all of those things went into a hat. And I would say that almost all of our cases got resolved, and because of that. One other thing I will tell you is, because the law is so complicated, and because the prosecutors, at least in my jurisdiction, are not always on top of these cases and on top of the law, you could basically, and the judge would have to go back and read the record, because most of the judges who sentenced them originally were not now the sentencing judges. So you would tell the judge, look, judge, if we go to a sentencing hearing, you're going to have to reread the entire transcript of this trial in order to sentence this person. And so there are a lot of different leverage points that you had to get the prosecutor to agree to a plea. And so out of the cases, 15 cases we have, 13 have pled out. And I would say most of those people got relatively good sentences. All those people are going to get out. We have nobody that was sentenced to more than 40 years.
So when I listen to your description of some of the factors that you looked at, I'm imagining a master grid somewhere.
Yes.
Did you, in fact, and would you recommend that as we think going forward with Miller cases, again, each state will differ, but to the extent that time of conviction matters, that the applicable state law may have changed over time to, in a way, slot these individual defendants into time periods, so that where you have a more favorable sentencing scheme, you might want to start there.
Absolutely. As well as, and I think to me the most important factors are who the prosecutor is, who the judge is, and you may get a very friendly judge who is willing to hear about how kids are different and the many ways in which kids are different, which, by the way, I would encourage lawyers to use the actual language in the 3 cases. Because that language is very powerful. And in Florida, we tend to say, okay, that's what the Supreme Court of the United States said, but we go into our little worlds. I have tried to use that language and try to convince prosecutors and judges that it means something. And if you get a friendly judge, you can go a long way with that. So a lot of these cases will depend on who the judge is, and in some cases, who the prosecutor is. I had a case, just one last thing. I had a case where the prosecutor was the original prosecutor on the case, and she was a very tough, hard-bitten prosecutor who was not going to give me any relief. And I had another case in which it was a younger prosecutor who understood the kids are different and was very sympathetic to the position that I took. And so it depends even on who the prosecutor is. And you've got to figure out which case should go first, and then you have more leverage with the second prosecutor.
I think that Steve makes a great point about the fact that we now have 4 Supreme Court cases in which the U.S. Supreme Court has used this kids are different language to drive its result and to really force a different sentencing scheme for juveniles in the adult system. And I think that over time, courts will have to adopt this as really a changing paradigm for sentencing.
Right.
And it's really critically important that we use that in each of these cases going forward.
Right. One more thing. because most of the lawyers who are handling these cases in the defense world are adult lawyers handling juvenile cases, the same thing is true of the prosecutor's office. Most of these prosecutors don't really understand how kids are different and the many ways that they're different and the effect that that should have on their decision making. And so you also have to educate the prosecutors, not only by showing them the cases and what the cases mean, but get them educated as to the fact that kids really are different. And some prosecutors, not all by any means, but some prosecutors become sympathetic to that.
Sonia, let me ask you, sticking with Florida, I know that there were some initial resentencings immediately after Graham that led to extremely high sentences. Many of them looked like virtual life sentences. However, you quickly came together and tried to coordinate and manage what was going forward. How did you do that?
Well, the first issue was, what do we do with these cases that got through the door and ended up with 90-year sentences, 120-year sentences? Primarily, frankly, because oftentimes there were lawyers who didn't understand that juveniles were different, or that one had to put on evidence to convince the judges of that fact. When I'm handling a case in Sarasota and I got a call from the JA about how much time I needed for the hearing, and I said probably a couple of days, and she said, "Oh, I've got you on the calendar for an hour. Isn't this just a resentencing?" And I think a lot of attorneys, unfortunately, that's sort of their mode. We're going to go in, then we're going to put the mom on, and then we're going to argue a little bit, and then that's the end. Even very good attorneys who get very good results. And I think we stepped in to essentially try to educate folks that you need to put on a full-blown mitigation case if you're going to go to hearing, and then also at the same time, we'd rather you didn't go to hearing. So we got involved first at the appellate level to try to mitigate the damage of those cases with very long sentences, and I can't stress enough how important that is to have an appellate team who can jump in and try to either change the direction of the law or reinforce good law that's being made at the appellate level, because of course that's where all of this will be worked out. From there, again with the help of Barry primarily, which is largely funded by Soros, the LWAP project there, we use them as a central clearinghouse, and then we put together a statewide team, or I should say they put together a statewide team of folks who could have their eyes on all of these cases. Ilona Piku is at the JLWAP project, and she's got a huge spreadsheet, and she knows where every case is and whether or not they have a lawyer and who the lawyer is. And then immediately we started doing trainings, online trainings for folks to learn how to do these cases. And I think that was sort of the thumb in the dam, and it slowed everything down, and now we've got most of the cases that have gone forward, about half of them, most of them were negotiated, which was exactly what we wanted to happen. And the ones that are still being litigated are the ones that we'll have to have hearings in, and we're not in any rush with those cases. You just really need to take your time with it.
So you make a good point, and I think we should talk about this, at least to just mention to folks that certainly in the Miller cases, and I think also in the Graham cases, there are these parallel tracks. One is the lawyers who are representing the clients in a sentencing rehearing or trying to negotiate a case. The other is at the appellate level. There's all cases are all over the place under Graham, and ultimately the Florida Supreme Court will decide what is a reasonable sentence and what is not a reasonable sentence. So it's really very important that lawyers who are litigating these cases in the trial court have an appellate lawyer and are working with appellate lawyers, and vice versa. It's really important that is coordinated, because I think otherwise you're going to be, the results are going to be all over the place.
That's a great point. So we have, again, because the Miller cases are so much larger than what we were dealing with in Graham, we're not suggesting that every Miller case have defense counsel, trial counsel, and appellate counsel, but the notion perhaps of thinking about an appellate team that's available in each state, some appellate resource that trial lawyers can access as they're working through these issues at the trial stage
And listservs.
and as they need to go up.
Listservs are great for that. If you can combine trial and appellate lawyers doing these cases on a listserv, then the appellate lawyers can weigh in on the issues that are cropping up in appellate courts.
So Carol, in Louisiana, similar issues, I know you have talked about pushing cases forward for negotiation first. How did your team sort that out?
We basically came up with about 12 criteria that we looked at and identified in each case that we thought were significant, most of which Steve touched on. We looked at who the DA was, who the judge was. For our older cases, many of the people that had actually been part of the initial trial had moved on, so they didn't have the same sort of personal investment in the case, and that seemed to matter. We looked at the age of our client. We looked at whether or not there were co-defendants, what their sentences were, whether they were older, whether they were already out of prison, those sorts of things. But the other very important thing that hasn't been touched on yet that we looked at was whether there was any sense of the victim's position. In some of our older cases, where people had sought commutations or had been in court previously, there was either nothing from the victims where the pardon board had reached out, there was no comment, and in some cases we found letters that had been written to the pardon board saying, I think this person has served enough time, I think that they deserve to be released. And in some cases, through conversations, we found out the same thing. So knowing where the victims stood, ideally where they were willing to say, I think this person has served enough time, or where they were going to say nothing. But we needed to know if they were going to come to court and very actively oppose any sort of relief, because that was a really important consideration for us and the judges and the DAs, and ultimately the parole board look at that and weigh it very heavily.
And don't write off the victims, even if you know that they're going to come to court against your client. Go see them, before court, and see if you can make some inroads that way. Have your client meet them if you think it will go well. Do whatever you can to get the victim, if not on your side, at least neutralized, because that, I think, is the single most compelling factor for the judges. And they're now going to have, in some cases, 15 years of the victim's hard life after the crime, potentially, that could come to light in a hearing. Now, you would argue that it shouldn't, but potentially that's what you're up against, and I think it's very important not to write off the victim as a potential ally.
I think that's absolutely right, and I think that outreach is important. I would say also be aware of what statutes are out there in your state regarding contact with the victims. As it relates to our clients, there are very clear laws that prohibit them from having any sort of contact unless there's a whole process through the Department of Corrections that is gone through and that is initiated by the victim. But I think it's very, very important regardless, because oftentimes the only position out there is one that was garnered through a question, which we saw in one of our cases where the prosecutor said, well, if this person is released, aren't you scared that they're going to come and get you or go get somebody else? That elicits a very different answer than some of the more sensitive approaches might.
We've talked about the importance of coordination and the value of listservs, which I think is an important issue to stress, that trying to get lawyers to talk to each other so that you can manage this process going forward. It was important in Graham. It will be important in Miller. I'm curious, was there any effort to work with the judiciary to try to manage the process? So, for example, you could have a grand scheme about which cases you want to go forward, but you have judges in particular counties who are scheduling cases for resentencing. Was that a problem? Was there an effort or an ability to actually manage how the judiciary worked with these cases in either Louisiana or Florida?
We did not attempt to work with the judiciary, but it was less of a problem for us, I think, primarily because a lot of the cases were so old that there wasn't a lot of interest in moving them unless we pushed to have the cases moved. So we were able to control some of the timing of that. So it was not an issue. I think it's going to be more of a challenge with Miller because of the number of cases, and so we're going to have to think creatively about how we're going to do that.
An issue in Florida?
Yes, in some cases. I mean, our worst circuit moved the cases along pretty quickly, and there really wasn't much we could do about that, and that's the circuit where we've had a sentence as high as 170 years. In other cases, I think it's just a matter of the judges, again, not really understanding what's involved in these cases. I mean, I treat them almost as if it was a death penalty case, and that's a hard leap for a judge to make, I think. And I know in at least one circuit, we had a private attorney who met with the judges and gave them a presentation about what these cases are going to be like and how much time they take, and that helped a lot. I think, make use of your NACDL affiliates, because a lot of times, unfortunately, the private attorneys are going to be the ones who have more pull with the judges, which is obviously not something that should be the case, but it is in many circuits in Florida. We have Factl is a huge leader in not only taking the cases, but in educating the judges and being negotiators, because they're not litigating these cases all of the time, and so they're seen as kind of not the true believers. They're the people who are just trying to make the system work, and I think the judges are often, unfortunately, just more receptive to that. And so your private attorneys can do a really important job in educating your judges.
I think it would be important to acknowledge here that in the wake of Graham, again, we know there were about 120 or 130 cases. In Florida, have you gotten through all of the Graham resentencings?
No,
We're about
50%, halfway.
Yeah.
So about halfway through, and that's 2 years out.
Yeah.
Right.
How about in Louisiana?
I would say we've moved about 3/4 of them through the courts, but a number of them are now parole eligible, and so we still have to move them through the parole hearings, and that piece of it is really just getting started.
And is it fair to say that at least in Louisiana and Florida, actually there have been no parole hearings yet for any of the Graham cases? That'll be the next
That
hurdle.
is the next step, yes.
Okay.
And I can't stress enough how much you do not want to hurry this process. The reason we have half of our cases still to go to hearing is because that's by design. The negotiated cases are the ones that have gone forward. The cases where it looks like we'll have to have hearings, the lawyers are still working, and you do not want to rush to a hearing. Your client is going to be very eager to do that,
Right.
because they're serving a life sentence and they've got a chance at release. Do not fall prey to that notion, because it takes a lot of work. And if your judge is forcing you to go to a hearing before you're ready, then absolutely get with an appellate attorney and find out what you need to do to preserve that issue, because there is a lot of work to be done in these cases.
So let's talk about the hearings. Obviously, each of you has been involved in a resentencing or more, of course, in Louisiana and Florida. I'll start with you, Steve. I think what we'd like to hear is, what kind of information did you think was most important? What kind of information did you think was important that it turned out the court wasn't that interested in? What information was harder or easier to obtain? What kind of expert testimony, witness testimony, just an overview of how you approach these hearings, what worked,
Well,
what didn't?
I will tell you, fortunately, I have not had a hearing yet. Will have 2 coming up, but I have not had an actual hearing yet. But understanding that, I would say, as Sonia said, it's very much like a capital case. You have to spend a lot of time with your client, get to know your client, get him to understand the dynamic of what's going on in the court, what he can say, what participation he can have, talking to the victim, talking to the judge about being different now and understanding what he did. I think you need to get all of his records as a child, his school records, and that includes getting releases from your client to get those records. And you need to go through all those records and find out why he did what he did at the time that he did it and at the age that he did it. You need to get all of the records from the prison system. That's really very important. All the disciplinary reports, all the mental health records, all of those things, I think, are critical to you to begin to analyze how he has done since he committed this crime. And what I have tried to do in every case is to get at least one, normally 2, people involved, and this is going to be very similar to the Miller cases, to try to find an expert who can talk about what this prison record means. It's a very good record, or it's not as bad as it looks, but to have a prison expert talk about what prison is like, how well this person has done in relation to that, and how he may have started out as a young child who is very threatened by the situation, and now, more recently, he's done very well. The other thing I try to do is to have a child and adolescent psychologist or psychiatrist interview my client now. And then they're going to be able to talk about youth, the many factors involved, how kids are different, how they, in almost every case that I have had and have now, they're co-defendants, and most of them are older co-defendants. And children are obviously, one of the things about kids is that they're obviously influenced by other people. And so all of that can be explained by a psychologist or psychiatrist. But I really focus on trying to get an adolescent psychiatrist, not a forensic psychiatrist or psychologist, but an adolescent psychologist who can talk about the many ways in which kids are different, and they can also talk about how different this person is now than he was at the time of the crime.
Carol, let me ask you, I think that a lot of listeners who are anticipating doing these hearings likely are wondering what is the relative importance of who this person was when they were convicted. That could be in some cases 30, 40, 50, even 60 years ago, versus the importance of who they are today. So how did that play out in Louisiana?
I agree with Steve, and I agree that you have to get all of the records, use those sort of experts. What we found in Louisiana with many of our cases, and particularly the older cases, but pretty much across the board, that information regarding childhood, regarding environment, abuse, all of the issues that we know are so important, were less relevant or less important to the judge and even to the DA, which made us realize how much education we have to do there in bringing them up to speed, as Steve was saying earlier, on the importance of this. I think it still needs to be developed and presented, of course. But what we found was that what they were more interested in and what seemed to weigh more heavily was disciplinary record in particular, and any education programs, accomplishments, things like that. And then the other thing that everyone was interested in, where release or potential release was an issue, was we needed to have a good reentry plan. Yeah. We needed to have, where are they going to live, who are their supports, and so some of the accomplishments they had, which would be translatable to job readiness, things like that, were really important. And then as to the disciplinary record, and I think that's where, cultivating expertise, cultivating experts on what these records mean is really important, because you will see almost across the board, and this is with adults as well as those who go in as juveniles, those early years are rough. There's a lot of adjustment, there's a lot of self-preservation, but particularly for kids who are so much more vulnerable entering the system, you're going to see those first few years where there's going to be a whole lot going on. But what's happened in the last year, in the last 5 years, I know in Louisiana, to be parole eligible, they look at the last year. They consider that last year most relevant in doing risk assessment and things like that. But those were the most important things. And then the other thing that was very important, of course, and I mentioned earlier, was whether there was any, whether the victim had a position on it.
Sonia?
Yeah, I would echo all of that. I would just add a couple of elements that I've tried to use, one of which is proportionality. You can go back and try to get stats on what these offenses, what kinds of sentences these offenses were garnering at the time, and you'll often find that they're much, much lower than what your client got. And so if you can say to the judge, 60% of folks for this crime in that year got 7 years and my guy got life, I think that's very compelling. because any judge who hears these crimes is immediately going to go to that place. And so what you need to be able to do is say, yeah, but look at this guy who did that crime and what he got, and he wasn't even a juvenile. So that can temper the reaction to the crime, I think, that the judge will inevitably have. You can also think about limiting the extent to which the state can talk about the crime. This is to the extent that we're doing resentencings, not original sentences, but this is a resentencing pursuant to a decision that says we must provide defendants with a meaningful opportunity for release based on maturation and rehabilitation. That is what this hearing is about. Is my client mature and rehabilitated, and will he do well on the outside? We know what the crime was. That hasn't changed. And that's not, you could argue, even relevant to what the judge is looking at. Now, you won't keep it out, but you could try to minimize the extent to which the crime is the focus, because I think that really plays a huge role. And I can't stress enough the importance of having someone who gets not only the juvenile brain, but the kinds of psych testing that can be done to both adults and juveniles. When your kid went into prison, they had some psych tests done. I mean, they're in the record somewhere, and you need to get them. And many of them probably had antisocial personality disorder diagnoses. That test cannot be given to juveniles. You can't diagnose someone with antisocial personality disorder before the age of 18. So if you don't know that, you're going to need to have an expert who does, and who can look at these tests and talk about why they're not either not applicable to your client, or talk about the factors on which these diagnoses are based, many of which are typical of juvenile behavior in the population at large. And so you can really neutralize things. I would urge against risk assessment in test form, because even if you've got a good person doing that testing, so many of the factors for risk assessment have to do with early childhood acting out, whether it be criminal behavior or truancy or anything. I mean, I went through a risk assessment test with my psychologist, just answering the questions myself from what I knew about my client, and all of the things that elevated his score to make him less capable of rehabilitation were the things that happened to him early on in his life, which are completely irrelevant to who he is now. So you cannot assume that even though your client is nice and non-threatening and educated and will do very well, they will do well on a risk assessment test. So I would caution against that. I don't see any reason necessarily that you need to do that. The plan for release is critical. You want to have a reentry program. If the person has had any alcohol or drug problems, you need to have counseling set up. You need to think very carefully about the family, and I think it goes back to the point of treating these as death penalty cases. I would caution not to take that analogy too far, because with a death penalty case, the person isn't going to get out. So in a way, the more abuse and the more problems that you can point to, the more successful you may be with your mitigation case. In these cases, the goal is to get the client out. So while there may have been abuse and there may be mental health issues, you need to be careful not to give a signal to the judge that that's going to make it impossible for this person to succeed outside of prison. And one of the ways to talk about that is really with this action plan. You know, he may have a terrible mother, but he's got this great dad who's living over here, and he's going to start living with his dad first until he gets a job. And this person has a construction company who might be willing to give him the work, and he did construction while he was in prison, and meanwhile he'll be going to counseling, and there's this reentry program that will supervise him. And you need to hand the judge essentially the nuts and bolts of how this person is going to make it, because otherwise, you know, they know what the recidivism rates are, and you know, it's just much easier to keep the guy in.
There are two things I could add there. I agree as far as doing risk assessments. In Louisiana, anyone who is going to be released, who is in prison, there is a DOC risk assessment that's been done. and that will be done. And so it's very important to know what that is, what the tool is being used, whether or not it's validated, and to understand it, because it's going to be there and it's going to come up. And so we've had to learn a lot about that, and that's where the importance of cultivating some people with expertise in that area to guide you through that and to interpret it. The other thing we found with reentry that has been very, very useful for us is that we have some formerly incarcerated people who served lengthy sentences who have now started organizations on the outside in Louisiana, specifically working on and working with reentry, and they've been very persuasive and have been very useful in talking about the programs that they have established and the things they can do with this person upon release to help with that transitional period.
Yeah, in Mr. Graham's resentencing, they had a representative from the reentry program who had actually gone to meet and speak with Mr. Graham and had approved him for reentry and could even talk about all of the qualities that Mr. Graham had that would make him likely to succeed. And I think that's a really powerful piece of testimony.
If you have a reentry plan and you've thought about it, and you have a really good plan mapped out, it gives a lot more comfort to the judge and to the prosecutor as, okay, this person isn't just going to go out and commit another crime. There's a structured program. There's all these different people that have relationships, good relationships with him. It's very important, I think, and we sometimes underemphasize that, but it's very important to have a very detailed and powerful reentry plan. That will take you a huge way in terms of getting a judge to do something that he is predisposed not to do.
And that would be true in negotiation as well as the resentencing themselves. So
Absolutely.
Can't underemphasize that.
That's right. I had a case where the prosecutor came in and he just said this is the worst case that he's ever prosecuted, and he's going to do anything he can to keep the guy in as long as he can. And by the end, once we had the plan in place and a bunch of other things, he basically said, I hope this kid does well. It was a remarkable process, and I think most of that was A, how the kid had done, and B, the reentry plan that we presented to him and say, look, we're just not going to let this kid go out to commit another crime. And he was very taken by that.
The other point that I took from this conversation was the distinction between death penalty sentencing and what we anticipate will happen in Miller. And Sonia's point about in death penalty cases, it's really life without or death. These individuals are not getting out. There is a reason to portray them as deeply sympathetic, and sometimes that sympathy is drawn from a record of abuse and other related factors. In these cases, because really the goal is to seek either, in very long-term cases, immediate or near-term release, it's actually a very different message that you want to communicate to the judge. That childhood trauma may be relevant, but it doesn't jump to the forefront in the way that it might in death penalty mitigation cases. So really important point to keep in mind.
Yeah, you don't want to find yourself saying mom abused him all his life, and by the way, he's going to live with mom when he gets
Right,
out.
exactly.
You know?
Exactly.
Right, or that, of course, we know there is other kinds of expert testimony that would draw other conclusions
Right.
from that.
Right.
So really important
Well,
point.
that's a very important point, and I think you have to be very careful. Obviously, he's mentally retarded, he's mentally ill, he was very seriously and permanently damaged because of the abuse.
Right.
That is all great mitigation, but it can be killer in this case, killing any chances of the kid getting out. But I think you can turn that around in many instances by saying he was horribly abused as a child, and yet nevertheless, look how well he has done, notwithstanding that. And that will begin to show the judge, or can show the judge, that he is actually has internal abilities to change, and he's a strong person, and that can get the judge to understand what he's been through. He's nevertheless a rehabilitated person. So you have to be very careful as to how you use that, and think about using that, whether you want it, whether you don't, and how to present it. Those are all the little sort of variations of what we do.
I want to make sure that we capture some of the key points that just came out of the resentencing process itself. Getting releases, which was something that Steve mentioned. So ensuring that you have the ability to get the kinds of records that you need, whether it's from Department of Correction, it may well be going backwards in some cases to school entities, to mental health facilities, to other kinds of provider services or provider programs, important to remember that you may need releases to get this information. The issue about experts, I think that this point about having someone who can speak to the ways in which many kids, when they first go into prison, do have disciplinary issues because of, in many respects, the trauma that they are experiencing being very young, being placed into a prison setting. So having that kind of expert testimony available in ways that we wouldn't normally think that that was relevant. I think this issue about reentry is an important one, and I just want to ask you all to talk about it from this perspective. So we know that we are operating in a resource-weak environment. So how were you able to connect with community resources or other kinds of public resources to even put reentry programs together? If you could speak to that.
We were fortunate in that there is a strong reentry program that was started by formerly incarcerated people in Louisiana, one of whom had spent 14 and a half years on death row. And so they're people who've served long-term and formed a nonprofit to develop the kind of reentry program that they would have wanted when they came home. And so it really is led, directed, and operated by the formerly incarcerated. So we have hooked up with them and worked with them on helping that program grow, helping the programs come in place, connecting them with, for example, universities, with social work schools to develop relationships with social workers, to get interns to be able to do work there to create the kind of counseling opportunities that these guys need. They've started computer literacy classes, things like that, and most importantly, they were able to get a building where they have apartments for transitional housing, because oftentimes some of these guys just need some time in between coming out of prison and going to live independently or going to live with family. And so we were able to partner with them and really are working with them to grow that program. And so they've done a lot of the work, partly because they're so committed to it.
And in Florida, Sonia or Steve, how were you able to generate reentry options?
It's less centralized in Florida. I mean, I think sort of each attorney is kind of on his or her own. We don't have that kind of a system in place, but it's a wonderful model, and I think we should work towards that. I think most circuits do have some kind of reentry program, one or more. To the extent that one doesn't have one in the right spot, you could do a couple of things. I mean, depending on the client and what their action plan is when they get out, you could potentially have them in a different circuit program. The other thing to think about is to talk to the prisons about what their reentry programs are like. We don't normally think of them as very good, but in some cases they may be. And your COs and administrators from the DOC are going to be very interested in being able to say to a court, we have this really good program here, and everybody who's getting released goes through it, and here's what they do, and here's how we get them ready. And it will be a nice ego boost for them. And so I think you would get positive testimony out of those folks, and it may help the judge feel a little bit better. It's very compelling at any time to have a DOC, CO, or administrator on the stand, whether it's talking about your client or the programs that are available, or even the lack thereof. But I know in Florida, every prison has a reentry program. And in the Graham case, actually, that was very important to the judge. He wanted to know, how long the defendant would be in this program, what was offered, what kinds of programs are offered. And part of the sentence in that case was contingent upon this person being able to access these kinds of programs.
We have a question from a viewer that is directly related in a sense to this reentry issue, and that is, it's pretty clear from what each of you has said that having a good reentry program was a powerful element, in particular in negotiation. What else made a difference? Reentry plus what else? What were the other top factors that seemed to be the most persuasive?
I would say the most persuasive thing besides reentry is convincing the prosecutor and the judge that your client is a very different person now than they were when they went in. I mean, that's really the holding of the cases that we're talking about, and that is the most important thing to emphasize, to educate them about that and to prove that that's the case. And the prison records and the mental health experts, whatever you need, and sometimes you need an awful lot, but that begins to get them educated as to how different this person is now than he was then and why he did what he did then because he was a kid. The more you can bring in the themes of the cases, the fact that kids are different and the many ways in which they're different, and he is a very different person now than he was then, and then you can prove it. I think that has the most effect, and that's frankly why I was able to resolve many of the cases I have, in part because there was a lot of work that the prosecutors didn't want to do, but also in part because we were able to convince them that this is a very different person now. And I think that's very powerful. And that is what the cases say, because it's true.
Yeah.
Carol?
I would say the same thing, and it sort of fell under the, what I would say the overall, what Graham talked about, the demonstrated rehabilitation. And so in our cases, we found it was both the disciplinary record, or lack thereof, their status in the prison. They have a trustee system in Louisiana, and so Class A trustee is the highest, the lowest risk or the highest level that you can get to, and so many were Class A trustees. And then there was also sort of education and other programs, anger management for those convicted of aggravated rape, the sex offender treatment program. And there were other ways in which they had either demonstrated leadership or for concern for others. Angola has a nationally renowned hospice care program, and you had some who had gone through that and who spent a lot of their a lot of their time helping others there. And so there were a lot of different things like that. And what I would say is they all sort of fell back on what we know in all our other cases, which is sort of the storytelling. What is the evidence? What are the witnesses? What is the information that tells the unique story of this person and their rehabilitation, which sort of reinforced all of what Graham says, which is, for those who have served longer, in Graham it talked about predicting the future, and in these cases you are in the future, and so what does the evidence from that time to now say? And that's what we really found was most persuasive.
Yeah, one other component of that is that the fact that we have family members who, for example, I have a client whose mother was 15 when he was born, but she's now 30. And she has grown enormously, and she has a much different perspective, and she's much more able to provide very good support system. She understands where she went wrong, et cetera. And those witnesses, people like that, family members, people that know him, ministers, et cetera, people who have followed him can talk about the progress that he's made and also talk about what was going on at the time. And they can be very also important, both in terms of a hearing, but also in terms of convincing a prosecutor or a judge that he really is a different person, that he's grown. And I have seen, and with my own eyes, the way in which he has changed, and I can tell you the many ways in which he's changed. That's also very powerful.
In many of these cases, obviously, the persons who know these individuals best are inside the prison, both corrections officers and other inmates. Was that relevant, for example, Sonia, in any of your cases? To what degree did you actually look to the prison itself as a source of information about your client?
Yeah. I'll just add one thing to the question before on press, which I think plays a huge role. And you're going to run into some prosecutors and or judges who are simply looking to their next election. And frankly, whatever you say about a juvenile being a juvenile is not going to make a bit of difference with them. And so you need to think about other ways to control the case, one of which may be, this state attorney's coming up for re-election in November, let's try to put this off until December, because the last thing they're going to want is to be seen as soft on crime. And press in general, I think, is something you want to avoid with these cases, because that only yields a whole lot of stuff about the crime in the press, and or elected judges and prosecutors feeling they need to defend themselves. So I would say, for any case, but particularly those with which you don't think you're going to have a chance at convincing the judge one way or the other, based on the data and the experts and all of that, at the very least you can do is to keep it out of the press. And then maybe once you get to a hearing, or because you have a lazy prosecutor who just wants it to go away, you can say, look, there are no implications for you. I mean, you wouldn't say it out loud, but essentially that's the message. Let's just make this go away quietly. So I wouldn't underestimate the role that the press can play against your client. Even if you think you've got this great, terrific client who would play very well, there are all of these other factors that may prevent an early release for that person. So on the folks in prison, yes, I think overall it's only a plus to have those people involved. It may be other inmates, it may be COs, it may be wardens. I've gone to wardens and asked for affidavits about, a client of mine who was a snitch or something else. You've worked with this guy, what do you think he's like, And some of them will resist, most of them will resist weighing in, and some of their lawyers will wise them up to that after they've had a long conversation with me. But it never hurts to try, and what the lawyers will always say is we can't prevent our employees from talking and testifying and all of that, but our policy is to urge them not to weigh in on people's individual cases. Now, what I've done is send an investigator out either to the home or to the prison just to chat up these guys and see what they can get about the clients. Obviously, the client has given us their name as somebody who might be helpful. And once they've talked through it all and said whatever nice things they can say about your client, they may say, look, I can't testify, it's against our policy, and then you can just subpoena them later, and they've got all of that dialogue running through their head, and they'll generally say the right thing. You're not going to get as lengthy and fruitful a testimony as you might if you could have actually prepared them, but generally I think that's a terrific thing to pursue, because again, the judges are going to place a lot of stock in what a correctional officer has to say about your client.
And did you find that even other inmates, for example, Carol, in some cases, made a difference in terms of what they could say about your clients?
Definitely, and it depended on who our audience was, and for some judges that might not matter, or DAs, but it was a hugely important investigation tool, and it was certainly in some cases would be very good witnesses. But the stories that we got to get to know more in depth who our clients had become in prison, and sometimes the leadership roles they took. One of our guys, everyone called him Coach, because he coached and refereed through all of the different athletic programs, but in addition to that had served as a mentor over decades to younger guys who came in and kind of helped them navigate through that process of adjustment and maturation. And so those stories were really, really important in developing the narrative that we wanted to put forward.
Let me end with this question. We know that in the Graham case, the court, really in a sense, the only directive that the Supreme Court gave was that these individuals had to have a reasonable opportunity to obtain release, to demonstrate growth and maturity before the expiration of their sentences. In Miller, it seems that we have the Miller factors, where Justice Kagan literally laid out several factors that she deemed relevant, characteristics and attributes of adolescents that she thought courts should consider in resentencing. As you're thinking from your experience in working with Graham with not a lot of guidance and overlaying the Miller factors, how do you think that will influence your handling of these cases, as well as how prosecutors or judges might respond? If we can we'll start with you, Sonia, and go down.
Well, in some ways, I suppose it'll be easier because you will have these factors, and it's a little bit more of an instruction booklet for the judges. On the other hand, the sentencing options are so much less well-defined in Miller that I think it will have its own challenges in that way, and there's a complete lack of clarity in these cases so far. I think I think because of the crimes being more serious, it makes the press rule even more important in my book. It makes the negotiation rule even more important. And finally, the appellate rule, because there are a lot of legal issues that we're working out in the appellate courts in Graham, and there are going to be even more in Miller. I'm on a listserv where, every other day we're posting something about how to approach Miller and its legal consequences. And, you need to present the whole picture in the trial court, but then again, you need to be set up to be able to litigate these issues on appeal right out of the box. And I think that's really important.
Carol?
I think the one of the biggest things that I see in how we approach it is that it creates an opportunity in the sense that the Miller factors now give us additional leverage, in fact, pretty persuasive, with our judges and DAs who were resistant to this evidence, to this information, and saying it's not relevant. And now we have the Supreme Court saying unequivocally it's relevant in these cases and courts must consider it. So I think it presents an opportunity to push that further than we were able to with Graham. I think that that's true both as to negotiations and as to preparing for sentencing. I think the challenge is going to be, because there isn't guidance as to what the alternatives are, and they refer to a term of years, life with parole, and then life without parole in those exceedingly rare cases, creating, a sentencing hearing and a mechanism for getting this before the courts so that all of those options are present.
Let me just add one thing to that. I think you can use the Miller factors in Graham cases as
Absolutely.
well.
Yeah.
I mean, I think this is, you should be presenting this as an evolution of the court's thoughts on juveniles, starting with Roper and going forward, and that it's all relevant to the cases that came before. So the Miller factors are just a refinement of the initial holding in Graham, and I would absolutely say that they're applicable in these Graham cases.
And I think that's absolutely right, and that's what we've done. And now, armed with Miller, can say, well, actually, Judge, this is relevant, and the Supreme Court has now said you must consider it.
I think that it's really important for judges and for prosecutors to know that the Supreme Court of the United States has found that kids are different.
Mm-hmm.
They don't handle kids' cases normally, or they see these really horrible kids come into their court who have done terrible things, and obviously the solution to do is sentence them to life without the possibility of parole. But you need to educate the judges, and you need to tell them what the Supreme Court of the United States has done, based on a lot of the amicus briefs and based on the holding of the court, that kids are different, and you need to convince them of that fact. And then you need to educate them at the actual case goes to trial or goes for hearing. You need to have adolescent psychiatrists and psychologists, and you need to prove the point that this is a very different person now than committed this crime, and that's because, in large part, he was a kid, as well as all the mitigating evidence. I think it's a wonderful opportunity, but it's going to take some teaching them and then taking the time to educate them on what it means to be a kid.
And I would say, in wrapping up, that I think that, in a way, what Graham provided, I think, in thinking about resentencing, was an opportunity to impose an outside term.
Yeah.
That outside term was a meaningful opportunity to obtain release. What Miller provides is a set of criteria to think about how we reach that outside limit. And I think that what we hope will come out of both of these cases is really a blending, as you all have said, a blending of the lessons and the holdings of both of these cases to really guide courts in making these decisions going forward. I want to thank again National Association of Criminal Defense Lawyers for providing the forum, the technology, the film, the camera, for us to do this. We're greatly appreciative to them for this opportunity, to the other partner organizations who have co-sponsored this webinar. We hope that we have sparked in our listeners' minds an opportunity for dialogue and further conversation, and we anticipate that we will be able to provide further webinars going forward as we sort out the implications of Miller across the country. So thank you.
Thank you.
Thank you, Marsha, and I want to thank our excellent faculty and ask you all to stay tuned for the next webcast, which is going to start at 11:30. That one is going to be on resentencing juveniles convicted of homicide post-Miller. And I also want to let people know that although that is the focus, you're also going to have some great strategies and useful information that can be applied to your other sentencings that don't fit exactly into the post-Miller homicide category. So stay tuned for that. As Marsha said, we have more webcasts coming up, and specifically save the date for September 25th and 26th, where we're going to have additional webcasts about representing juveniles on topics such as communicating with your juvenile client and using the research on adolescent development in all stages of the proceeding, motions practice, placement decisions, and all of that. Thank you for watching.